Tēnā koutou, tēnā koutou, tēnā koutou katoa. I won't thank all of the speakers who've introduced me, but it is a real pleasure and a privilege to be here when I see those who've come before me, and I especially make mention of Emeritus Professor, the former Attorney General, and I know what it's like to be an attorney, so Margaret Wilson, the Honourable Margaret Wilson, thank you for coming. Thank you to Norris Ward McKinnon for the invitation to deliver this lecture and for all that this firm has done to further legal education. I acknowledge the Faculty of Law and Waikato University for its support. Thank you. I also acknowledge Waikato Tainui Iwi, and I'll digress a little. For the last 10 years, I've represented the Crown in a long-running series of arbitrations between Waikato Tainui, Ngāi Tahu, and the Crown, and the results of which are generally private, but sometimes public. And there have been a series of decisions and agreements which both sides say have been helpful to clarify the meaning of their treaty settlements. We're actually up to round 9. Not only their treaty settlements, but the relativity mechanisms in each of those. Now, many of you will know this, but some might not, that some of those decisions have resulted in very significant payments to iwi, and there are only 2 iwi that have these relativity mechanisms, Waikato Tainui and Ngāi Tahu. And the process and the benefits that resulted are testimony in large part to the foresight and the commercial acumen of Waikato Tainui, in particular Sir Robert Mahuta, and one could write a book on that. That was the first historic treaty settlement, and as I say, one of only 2 that have this mechanism. So congratulations, Waikato Tainui, and my respects to them. My focus this evening obviously is how will technology impact on the law and the legal profession, in particular some matters which I think are going to influence immediately and significantly. As Solicitor General, as you heard, from 2012 to 2016, I did have some influence in bringing Crown Law and the government legal network into the digital age. And as you've heard, since 2016, I've been at the bar. But I also, and my wife, Catherine, thank you, has borne with me. I've been involved in 3 technology startups, 2 of which are in the legal area. If you know anything about startups, you will know that most don't succeed. So it's a victory of sorts, even to remain in business. So I'm going to claim that victory. One of the things you learn rather rapidly is very hard to change behaviour. And that is so true for lawyers and the legal system. So with that theme of change, I wanted to focus on the digital strategy that we've heard about, on Te O Reka, which is the case management system that's about to be rolled out, and Te O Marama, which we've heard in previous lectures, a very important initiative particularly in the district courts. And along the way, I'm going to talk a little bit about artificial intelligence. You couldn't comment on this subject without it. Te O Marama, as I said, was the subject of the excellent earlier lectures from Chief Judge Taumanu and Judge John Walker, and there's a lot in there that I want to touch about. So in broad summary, I'm going to cover the digital strategy, I'm going to cover Te O Reka and what that might mean, and I'm going to cover how these might interact with Te O Marama and can they coexist. And fourth, I'm going to touch upon just some of the challenges that arise from these transformative initiatives. Some of the challenges obviously arise from the New Zealand Bill of Rights Act, issues relating to tikanga, and I would say immediately I'm not qualified and won't give a view on that, but I would like to raise some issues which are obvious to me. I want to talk about artificial intelligence, and I want to talk about workplace pressure, which I think will be relevant. But my central point, my thesis, is the digital strategy for the courts is a marvellous step forward, and that Te Ao Reka, I hope, will be transformational. It is, in my view, imperative that Te Ao Reka is successful and widely embraced. But bear in mind, of course, that paper's going to be around for a long time yet. In my view, it's critical to the future of our court system that Te Ao Reka succeeds. And if it doesn't work, then fewer and fewer people will obtain justice from the courts, and more will go elsewhere. And I'll talk about that a bit more. I also believe that Te Ao Reka and Te Ao Marama are compatible and can coexist and can strengthen each other. I note for completeness, of course, that the proof of that will take many, many years to play out, so like a politician, I can be as optimistic as I like. And I immediately acknowledge that there are really big challenges ahead for all involved. Te Ao Reka will not be all positive. It will not be all plain sailing. In order for it to work, we all are going to have to change our habits, and we're going to have to challenge ourselves. And one of the aspects I'll comment on is that for lawyers and judges, in my view, it's going to involve increased pressure, at least until it becomes second nature, and I'll come back to why. So, as we heard earlier, just coming to the digital strategy, in late 22, Justice Goddard, who leads this for the judiciary, released a draft for consultation. He consulted widely, in particular with also, the profession, judges, lawyers, etc. In March, as we've heard, the Chief Justice released the final strategy, and in that, Her Honour said, the judiciary is responsible for administering justice through the courts and providing just outcomes for all people. To achieve this, court proceedings must be simple, accessible, and timely. Well, all of us know that is a real challenge. Her Honour went on to say, they must be conducted in a way that enables all people to fully participate in the proceedings that affect them. Again, a huge challenge. Her Honour said, using technology wisely has the potential to be transformative. Technology will help address the challenges, and went on to give examples experienced by people with disabilities, people who are neurodiverse, people who have English as a second language, and people for whom cost or family and work commitments make it hard to travel to hearings. So the digital strategy is all about the judiciary's objectives and guiding principles for the use of technology. Again, in the strategy, it says the processes must be capable of delivering just outcomes for all members of our society, and these words again, in a simple, accessible, timely manner. So what's the current state? Well, Your Honours here will know well, and the litigators here will know well. It may not surprise anyone to know that the courts and most tribunals work with paper files. Not all. The Waitangi Tribunal works incredibly well digitally. But you may be surprised to know that the official record of every court is a paper file. All judges and all court lawyers have experienced the difficulty of lost files. I had a case not so long ago where the district court and the high court disagreed about where the file was, and neither of them had it. So we've all seen that. In addition, participants are not able to see the progress of a case online. There's a lack of flexibility to allocate resources because, of course, the file is in one court and it can't be seen by others. And we have to remember, and this is not a criticism, but the courts are not focused on efficiency. It's fair to say courts, and we all are struggling with that. And yet the district court and the high court legislation at least, requires the chief judges to ensure the orderly and efficient conduct of the courts. At the same time, they don't get given the tools to do that. Let me give you just some examples. And because that's on a massive screen, I'll just see if I can get it on mine. Just compare that data, the number of finalised criminal charges. This is from the most recent justice data. And these all coincide with the start of the district court when it became the district court from the magistrates' court. It's quite striking that I'll show you a graph in a minute just to see those numbers. There's a bit of a blip, but generally it's trending down. So from 350,000 roughly finalised criminal charges down to 193. But at the same time, the population increases by more than 2 million. In 1981, we had far fewer magistrates, judges, far fewer. Now we have 180, many of whom, not all, but many, are doing criminal work. And it's not because the courts aren't working hard. They definitely are. The judges here will evidence that. But the cases are more complex, they take longer, they've got more procedural steps, and our system is clogged and not efficient. So that is one aspect. That's just the criminal cases. The stats for civil matters unfortunately don't paint a better picture. In short, people do not use the district court, very rarely use the district court for ordinary money claims. Its jurisdiction is up to $350,000. Now you imagine in a matter where you were owed $300,000 and you literally cannot afford to litigate that in the district court. You have what I would call a grim confluence of a growing need, an inefficient service, no disrespect, an ageing workforce, look at many of us, and an inability to pay. And so really, we're staring at the train coming down towards us, and we have to adopt digital systems. And it's easy to see if they're working properly, and it's a big if, what they could do for transparency, for efficiency, for resilience, for the carbon footprint, for just updating and keeping current. So the strategy addresses, okay, well, what do we want from this? And it's got some guiding principles, as you'd expect, consistent with core values, consistent with core constitutional responsibilities, judicial, for example, judicial control of the information, keeping it separate from the executive, the ministry, people-centred, inclusive, reliable, secure, transparent, flexible, implementable. It's got to actually work, properly supported training, etc., data-driven, based on proven solutions. We're not going to build it ourselves, thanks. So they're not really asking for much, are they, the judiciary here? It's reasonably straightforward. It's daunting. The demand is daunting. And te reka, which literally translates as the sweet flow, and some of you litigators might chuckle, the current system has never been described as the sweet flow, but it should be that way. So the te reka is, and I'll come to a bit more detail, but fundamentally it's the digital case management system end-to-end that creates and maintains the court files. A fully digital document management, case management system, and much more, obviously. The portal to get things in, the assistance to manage it through the process and then managing the output, and of course integrating audio, visual, etc. And those are some of the other aspects of the broad strategy. Remote hearing technology, we all know about that. We know how fickle that can be at the moment. Great when it works, terrible when it doesn't. Reliable physical network infrastructure, and the training and support to deliver this. Now, forgive me for telling you, those who know this well, you also have to remember that this is being delivered by the judiciary and the ministry. And remember that judiciary are responsible for the conduct of the business of the courts, and the ministry are responsible for funding, providing and operating the system. So my sporting background says, okay, well, I'll give you a sporting analogy. The judges are the referees on the field, and they control the rules of the game, and they control how we watch the game. But the ministry provides the ground, the stadium, funds the security, the ticketing, the catering, the broadcast, and the technology to make sure the game can take place. So nothing is more apparent than the two have to work together to deliver this. And therefore, Te Oreka obviously is a joint judicial and ministry project. The procurement process started in October of 2022 and it finished in August of this year. Some may have seen it in the media. The contract was awarded to DXC Technology, who are a Microsoft partner and will deliver Microsoft technology. There are two other New Zealand companies that are involved, one of which I'm the chair of, which is Immediation. It's a platform-based product, so they're building particular applications on top of Microsoft cloud-based services and applications. From what I've seen thus far, it is immensely powerful, but the proof will be in the delivery. The Ministry of Justice have stated the estimated cost is around 170 million at this stage. It's a very significant project, and I'll come back to a bit more. But thinking about the strategy and just what are the likely implications, might just show you. Now, this is a little hard to read, but this is the future state of what we're aiming for in the family court. And if you focus on the top line, it's really about taking out the paper and enhancing the process for the user. So you come into the system on a portal. You can get help either by digital methods or phone. You follow step-by-step instructions. If you put in information once, that's all you need to do it. Other agencies can be joined as necessary, you can imagine, in the family court. There is notifications online. Of course, depends if there are email, text provided, but provided you've got that. Digital case management, automated scheduling, automated workflow. There's a lot in this. Tech-enabled alternate dispute resolution and conferencing, interactive wayfinding, including physical, and then a hearing in court, which might be a hybrid, might be physical, might be online, and then a determination entered in the system, out to the parties, published in accordance with the court rules, and augmented transcription, etc. All that's the future state. Now, of course, that's going to be incredibly challenging. Judiciary, court staff, legal profession will need to be flexible as they adapt, and the ministry is really going to have to develop its capacity to support. It depends on all sorts of other branches of government, one of which is key, the executive, sticking with this project through thick and thin, because it's going to be tough. Carl Crafer, the Chief Operating Officer in the Ministry, and I'm quoting him, said the project was the most significant change in courts history. And I'm quoting him again, so we wouldn't want anybody to underestimate how big this is, he said. Not just for court staff, this is the interface with the profession, with judiciary, for staff, police, corrections, everybody. Now, there are some incredibly obvious challenges, and you will have picked them. One, they will be driving the car whilst changing big parts of the engine and the wheels, possibly. And we know how hard, and I've said that, it is to change habit, practice, and the current status quo. It takes a massive impetus, a pandemic, for example, to get AV hearings across the line. So, and if you think of a lot of the people that Mr. Crafer mentioned, court staff, legal profession, judiciary, are, like me, north of 50. We're not digital natives. This is not our, it's not our ordinary game. In fact, it's going to be incredibly positive and will create a lot of legal tech jobs for those who are capable, because frankly, no disrespect, but I find it a lot easier to get someone a lot younger than me who knows what they're doing. And I suspect law firms, the court, will do exactly that. And I'm not being flippant, but let's face it, almost none of our generation really understand how the technology works. I mean, I myself don't know how my fridge or my toaster works, but I use them every day and I'm satisfied they do. And it will be the same. The other pressure which I've talked about is that lawyers know that fewer and fewer senior lawyers are willing to provide legal aid services. And I welcome my colleague, Philip Morgan KC, who over the years has done incredible service in this area, and in fact did a massive service for me as Solicitor General when I appointed him to lead the Lundy retrial, which he was reminding me about. And then I was sent down to court to check how it was going by the then attorney, who was a little bit nervous, as they sometimes get. I'm not sure if you remember that, Margaret, but sometimes they get nervous about cases, and that was just happened to be one. Anyway, but there are fewer and fewer people who are like Mr. Morgan KC and are willing to do it. And primarily that's because it's extremely low remuneration and the paperwork is massive, and literally paperwork. You might have seen the recent media about the increase in self-represented litigants, in particular in the family court. I'll just show you this. The number of people representing themselves in the family court has more than doubled in the last 10 years. More than 70% of civil cases in the district court involved a self-represented party. And you can just see those numbers, about more than 70%, and that was 7,232 cases in that last year. 72% involved a self-represented litigant, compared to much less, 3,000 odd less, about 50% in 2015. Most lawyers and judges will, in a frank moment, and I'll be frank, tell you that self-represented litigants are the bane of their existence. They are bad for our system in so many ways. I'm not saying they can't be there, but they're bad for our system because ultimately they're not able to focus, they can't refine the issues, they don't know what's relevant and what is not, they cannot separate the emotion from the issue. And for all those reasons, the real problem is they take up much more time than their case deserves. Lawyers and judges are obliged to bend over backwards, and they do, to help them, despite we know all of this. Most litigants in person, I'm sure, are reasonable people who can't afford a lawyer. Some are unreasonable. Each deserves a fair process, but not to the exclusion of other court users. And this is where the problem lies. They take up more than their fair share of the resource and time of judges, court staff, others. So the opportunity there for technology is massive. I probably don't need to convince anyone of that. Automation, online guidance, online alternate dispute resolution, and other digital tools such as chatbots, AI, automatic service referrals, and other useful prompts, that's where we can make huge advances, and Te Ao Reka has the capability to do that. I'm not saying it necessarily will, it has the capability. Now, there are many companies working on this. Some of us have been banging on about it for years. For example, in Canada, just by way of one example, this is the Civil Resolution Tribunal, and this is their process. It's entirely online for small civil matters, and they run through pretty much an automated system. They're using technology which Te Ao Reka will bring. It introduces much more, and perhaps it's an opportunity for us: online assistance, online negotiation, facilitation, and ultimately judicial decision-making. And two of the companies I've started in New Zealand, Mediation and Agreeable, are fundamentally about that. More affordable, faster, simpler access to high-quality legal services and access to justice. And really, they're about replacing physical attendance where appropriate with digital. And of course, and I'll come to this in a wee bit more detail, the digital strategy doesn't cover everything, and the devil is in the detail. Fundamental matters such as tikanga, fair hearing, New Zealand Bill of Rights Act requirements, the limitations, the appropriate limitations on AI usage, and I'll come back a bit to that. These things need a lot of work. They need to be considered, tested, refined, embedded, and fundamentally worked on in partnership with the right people. And just by way of example, there's mention of tikanga in the strategy, but not much in the way of how this is going to be incorporated. I note both the previous lectures, Chief Judge Taumanu and Judge John Walker, they're excellent lectures. They talk about transforming the system, reimagining the system, and also about technology. And Judge John Walker made the very important point about the tension between technology and procedural fairness. The degradation of the human connection when AVL is involved, and a best practice requirement for substantive proceedings of kanohi ki te kanohi under the Te Ao Marama model. And that, of course, will be a feature, an ongoing feature. But as Honor said, well, we need to weigh the benefits of efficiency in a digital model against the right to a fair process and a right to physical presence, and that's undoubtedly so. It's going to provide an interesting tension, but in fact the courts deal with it already. Obviously, one of the fundamental principles of our justice system is people must have a fair hearing. For criminal matters, that's Section 25 of BORA, the right to a fair and public hearing by an independent and impartial court. And in civil matters, procedural fairness and the right to the observance of the principles of natural justice. It's implicit, obviously, that fair hearing or fair trial is guaranteed. Once Te Ao Reka is implemented, we're going to see that tested, I'm sure. Are these processes substantively fair? But in my submission, the courts are already actually dealing with that on a regular basis, dealing with complainants, witnesses, etc., giving evidence by alternate methods, or evidence being admitted despite not being able to be tested in the usual way. Now, the strategy also contemplates, in the longer term, the use of AI tools to provide, and this is quoting from the strategy, to provide guidance to parties on potential outcomes, to assist parties and decision makers to identify relevant materials and organise and analyse these materials. Now, that's already contemplated and I can say has been discussed in the procurement process. For example, imagine as a judge if you had the ability to automatically summarise thousands of pages of evidence and exhibits accurately, the ability to sort the documents into sequence, grouping, chronological or otherwise, the ability to create a draft of a decision, an order, a minute. And anyone who's used ChatGPT or Bing or Bard will know both the power and the limitations of those. I mean, I'm sure many of you are using AI and sort of laughing or liking what you get sometimes. And in my view, inevitably, it's going to be a feature of this process. This process is about the quality exchange of information and exercise of judgment, parts of which you would think can clearly benefit from large language models and all they offer. And I did it in preparation for this, saying to Bing, well, pretend you're a judge with the arguments set out below and write me a judgment granting the application for the reasons set out in the applicant's argument. And Bing duly does it. Now, Bing is a Microsoft product, and Te Oreka uses a Microsoft platform, Microsoft applications. So it's not hard to imagine. It will provide massive opportunities, but also massive risks. And some of the opportunities are obvious, of course. The ability to work in your preferred language when interacting with the court digitally. Te Reo, Pacifica languages, Mandarin, those are in the, well, I've seen the prototype and that's what they can do. The availability of real-time help through chatbots, online guides, pop-up. You all will have seen them in help desks. Automated forms, and this is incredibly powerful, automated work allocation and rostering and scheduling. Now I'll come back to that, but working out who has time and which court is available and what AV facility, that takes a lot of time now. That will be automated. And of course, I've talked about some other examples. And I'll give you a frivolous example of there is a lot more coming. I'm not saying Te Oreka, but technology generally. Some of you may have seen that Meta, Facebook, have just announced the release of their new glasses in conjunction with Ray-Ban. And you'll all know the Wayfarers, I imagine. They allow for video, audio, and real-time AI assistance for the wearer. So you can look at a document and say, Meta, what's that? You can look at a person, Meta, who's that? You can look at a language or a written document, Meta translate. And think of the opportunity for, I immediately think, well, what if you're a witness and you're wearing that, or a judge? Real-time translation, AI assistance for questions. How will the judge deal with the witness who says, yes, I need to wear these glasses because I have a cognitive impairment? I might try it as counsel, actually. I'm over 50, Your Honour. The brain, I need these. And how do you deal with that? It's fascinating. And they're available in the US at the middle of October. US $300 for those glasses. Now, coming back to the more prosaic and mundane, the Te Oreka, I've talked about the vendor selected DXC, which is a Microsoft partner, two others, a company, Immediation and Systock. It's fair to say it was an incredibly detailed and rigorous process, in my view, from the outside. It will be an effective partnership between ministry, judiciary and the tech companies. It's an absolutely massive project and extremely challenging. And in due course, further details will be released, but we know that it starts in the family court. And consultation has started about, well, what are the principles that govern it for lawyers? And I found it quite useful to read through these and think, okay, what does that mean? First and foremost, lawyers will have to use it. And if you send something in by paper or email, it's not going to be accepted, barring exigencies, i.e. the system's down. But lawyers will have to use it. If you're required to file a document, that is met by providing the information to Te Ao Reka. Doesn't matter how many copies, what form or where, if you put it in the system, that does. It doesn't affect the right to pay the fee, I'm sorry, but a requirement to serve a document will be met if the person has said, yes, I agree to accept service, or if they have a lawyer. So you don't need to serve, you need to put it on the system. You don't have to provide information more than once, you can just confirm that it's there. Signing, digital. Witnessing, potentially digital, we'll see, but it's there. And I'm anxious, and many are, that these principles are further developed and enlarged so that we don't have to have forms behind glass that they talk about, or a replication of the old procedures. And the obvious is the swearing of affidavits and declarations. So I'm arguing, and I've made this argument to the powers that be, I'm not sure I'm very persuasive at the moment, but that affidavits should be able to be sworn digitally. One of the companies I'm involved with, Agreeable, we witness documents digitally. They are encrypted with the photo of the person signing them at the time, with IP addresses, etc. And the lawyer who's certifying that I have witnessed that doing the same. In my view, that's good enough, and I don't see the need for deponents to have to go off to a lawyer, an independent lawyer, and front up to a person they've got no idea, really, does it really add? Why can't we have a process where, even if it was recorded and it shows the person promising that the information they're putting in is true, and the lawyer or the registrar saying, well, I've seen their identification and I've seen them online saying that it was true. Do we get more from doing it in person? I'm not sure. I'll just check how we're going for time. Does anyone have the time readily available? 7:09. Good. Well, I wanted to talk a little bit about Te Ao Marama, but I'm going to be incredibly brief because when the Chief Judge talked about Te Ao Marama, he said that the district court should be a place where all people can come to seek justice, no matter what their means or ability, and regardless of their culture or ethnicity, who they are or where they're from. His Honour said, our ultimate intention will be to ensure to the maximum extent possible that the best available information is presented to our judges to assist them to make well-informed decisions about the people who appear before them. And essentially, in His Honour's excellent, and I recommend it to you, speech, he said that all these reports since the 1980s have said, well, the courts are failing to understand those who appear before it or who are affected by the court business. In essence, and he was talking about criminal, defendants, whānau and victims are leaving the current system feeling unheard and unappreciated. Now, in my paper there will be a lot more difficulty, but in my view it's no overstatement that technology can assist and possibly get in the way of almost every single aspect of te ao marama. And how may it coexist? Well, it's to deal with the many dilemmas that we have of people not being able to participate and not properly being heard or understood. Now, that comes down to fundamentally this question about, must we kanohi e te kanohi, or can we work in a hybrid sometimes for the right cases, or online for the right matters? And partly it comes down to the question of, is the court a place or a service or both? And I would submit it's both. And this was a theme from Judge Walker. And it's something that we've seen. For example, experts in mediation said you can't have a mediation without people in the same room. Then came COVID, and we had plenty of them. So the Chief Judge talked about te ao marama, and he talked about when people attend the court, they must enter through the front entrance. In a Māori context, this is similar to people gathering at the Waharoa, the front entrance of a marae. And His Honour said, I expect that bilingual and where appropriate multilingual greetings by all court staff. And from the first time first contact is made, it will be a natural and appropriate development. And of course, that's an important part. But if you think of the vision of the Chief Judge's vision in modern parlance, that could be, for some people, through a website or a portal, coming through the front door in their native language, guided by timely, plain language assistance, and then contributing to the process or the hearing when and how they want to, all on a mobile device. That is what Te Ao Reka will allow. In my view, the courts are full of the best legal brains we have and full of hard-working, high-quality court staff. But we don't have to limit ourselves to going there to see them. There's no cogent reason in my submission. I set out some more reasons for this, that the aims of te ao marama cannot be met by different methods of being heard where appropriate. I've got some cautions which I'm going to skip over. I would say there is a lot of controversy around some things in the courts at the moment. Section 27 reports for offenders, and maybe we can achieve the original aims of those is actually having people heard by way of recorded video, by way of AV, instead of these expensive, time-consuming written reports. I don't know. In my paper, I deal with some issues around tikanga, and obviously I'm not qualified to talk on that, but I'm just quoting some of the academic research as to how tikanga might be incorporated. And essentially that's hard work now with the people that do understand it. My final point, and I'll finish with this, and hopefully it's not too doomy, but the increased pressure, at least in the intermediate, is sort of obvious. We're going to see the ease of filing materials and the ease of getting them available and allocating them and all this, and allocating rostering and work. And judges, and I know, having spoken to one last week, he said, wow, hang on. So we're going to see work just popping up in our diary. And then we'll have a link and the entire file is there. Yep, that's right. Lists, hearings, other dates, automatically populated. And that's a little bit frightening, with respect. And maybe we're going to see a less downtime, less space for the normal activities that lawyers and judges are involved with, chatting to colleagues. Maybe with audio, visual, digital, we're going to see slight more opportunity to become isolated. I don't know, but the system is data-driven, as you saw from the principles. You can measure everything. So whilst there's going to be a lot more flexibility, judges might hold the hearing remotely. And just one point coming back to Te Ao Marama, digital enables far less formality. That's what Te Ao Marama talks about. I mean, who amongst us hasn't attended a Zoom hearing with a mismatch of bottom and top? Now, and we don't need to stand and bow in the digital world, and maybe it's right for some cases. Anyhow, my final point is just that the digital, and many of us will experience this, is a more intense environment in some ways. It's a more relaxed environment and less formal, but I don't know about you, but when you've had 6 hours in a digital hearing, you are tired and it is intense. So in summary, and thank you for listening to me tonight and for the privilege of being here, I'm a strong supporter of the digital strategy in Te Ao Reka. I believe it can work well and even enhance Te Ao Marama, but it is going to be a huge challenge, and we will need to be patient, open to change, and curious for it to succeed. I'm confident, but I'm also a touch anxious. So thank you very much for having me tonight.
Thank you, Mike. Karawa kaupapa nei, tino pai. So this is the Q&A section of the evening. That talk was, I'm sure for many of you, especially if it was for me, really set off a lot of avenues of thought, which I'm sure I'll be thinking about for the days to come. But I'd like to invite anyone who has questions before I pile in with my own questions. D. There's a microphone coming to you.
Thank you, Jesse, and thank you so much for a very interesting lecture indeed. I'm very fascinated by the idea, and I'm not surprised that it's here. I think this is expected that we would go digital at some stage in the near future, and it's excellent to see that work is in progress. I have a comment, a recommendation, and a question. So my comment is that we hear from parties going to the family court, for example, about the experience of engaging with the legal system, where some might find themselves totally clueless as to what went on and why the judge has made the decision they did. So there's been a study that's been done by this university, and that was the finding that a lot of people go to the family court and they don't know what has happened with their case and the outcome. That's my comment. My recommendation is that just like we employ a flexi mode of learning at the University of Waikato, where we cater to students who are on site in the lecture theatre, who are online listening to the lecture live streamed, and those who have other commitments that can listen to our lectures at their own time. So they have the flexibility of accessing our service with these options, and I think it's a great way of moving forward, because that's where the future is, and that's what people want, and the demand is being met. So I would recommend a system like that, where people who feel the need to engage with the court system in person get that option, and those who have other commitments that would like to utilize the online system, that they can do that as well. My question to you is, with platforms, some platforms are more prone to cyber attacks than others. If we are going to have this digitized system, how are you going to ensure that if there is a cyber attack or something, that there is going to be a backup, that your system is going to be safe and secure? So that's my question. Thank you.
Oh, thank you. Firstly, it certainly won't be me or any lawyer, and it's a great question. One often thinks about the security of your own laptop or your own, and then you think of the size and scale and power of a company like Microsoft, and you think, okay, well, how much must they throw at the security of systems that they're building? Now, we all know that nothing is fail-proof, but Microsoft themselves are building at least one data centre in Auckland. They already have data centres around Australia, and you would imagine that there will be fail-safes and backups around that. I don't know the detail, but I do know that the Ministry and the Judiciary and Microsoft and DXC have spent weeks and months on exactly that. So we'll see. It's something, I mean, almost no one's immune. The New Zealand Stock Exchange, went down for days, and some other very high-profile companies have been. It's those denial of service attacks, I think, that are probably most worrying.
Yeah, I mean, Waikato DHB had that issue recently, so.
I'd just like to make a comment about that. Offshore, that will impede with our privacy laws as well, and the parties need to be aware that their data is being stored offshore. So that's something to consider as well.
Yeah,
thank you.
Absolutely. And they, obviously I can't go into the detail of the procurement process, but data sovereignty was a very big part of that. So I'm pretty sure they have that covered.
There are also obviously tikanga concerns about data storage. Are those being?
Yeah, well, in my paper I touch upon that, the tikanga and aspects of that, and we'll see. But that's something that I would recommend people start thinking about it.
It appears that one of the challenges through COVID for the medical profession and all the delivery of their efforts regarding assistance of all types was that actually a large proportion of those in need in New Zealand have no access to digital platforms, to the extent that even a text message is not going to reach them, because the phone changes, they have no data, they have no phone, they have no access to the internet. What's going to be, do you anticipate, put in place so that justice is available to all?
Yeah, it's a really good question, and it was a significant part of the process, and I'm sure it will be an ongoing. Essentially, there's going to be dual processes, because whilst lawyers will be required, litigants in person won't be, and the courts will be available for in-person and paper filing, at least for the foreseeable future. But what I do think will happen is that courts will change. Courts will become more digital, with more hearing facility and more help for people to complete the forms or make sure they've got the right information. The other thing to remember is the one thing about New Zealand is mobile phone penetration's extremely high. We have something like, there's more connections, more mobile connections, I think it's roughly 6 million connections to 5 million people, 5.2 million people. So whilst I agree with you, huge challenge, mobile provides probably our best accessibility tool.
Any other further questions? So if you can wait for the microphone, that would be helpful. Okay, while you think, I have a question. One of the key points of becoming a litigator is there's a real apprenticeship aspect to it, going along to the lists and sitting and watching more senior lawyers deal with their matters. Is there a risk with the digitisation of that we're going to lose a real element of learning on the job for young litigators?
Yeah, I think that's right. I mean, the game will change, and maybe we learn, as many people do, as the university knows, people will watch their colleagues online. They may be in the same office, they may not. They may be in the same room, they may be miles away. But I suspect that the game will change. It'll take time. But you can imagine that some judges would say, well, I don't need to go to court to hear this interlocutory or this preliminary or procedural. Why do I need to leave my office? I'll sit here, everyone log in, Teams link, done. And more I suspect that will happen. In fact, I don't actually need to drive to court. I've got a series of list hearings all around the country. They've just popped up. And I can see all the files. I can have the court staff wherever in the country texting the parties, the lawyers, you're on now. And they come on. It's not hard to imagine. It happens in some situations already.
Thank you. I just wanted to thank you for a very thoughtful and insightful lecture, actually, and say totally the digital strategies where we're going. But I wanted to just offer some advice, because you did raise it, that you're going to make sure this is for the long term, so therefore you're going to need support, not only from the Ministry of Justice, but from Treasury. I was the minister responsible for digitising all legislation so we could all receive it online at no cost. And my regular meetings with the Minister of Finance to get extra funding were the most difficult meetings I had, and was very grateful that the late Michael Cullen agreed entirely. But you do need friends, because it's not going to happen, as you said, overnight, and it can't. It's an iterative process. And I should imagine that the costings you've been given are as accurate as can be foreseen at this time. But don't be surprised if they increase considerably, and that's when you'll need those who are really committed to seeing this through to the long term. Thank you.
Well, thank you very much. And I'm sure those that are responsible for delivering Microsoft DXC, and to a very small extent the other companies in which I'm involved, we might be giving you a ring. Influence is important, I'm sure.
Anyone else for Dean?
Yes, I know that Justice Goddard and other, Victoria McLaughlin, who leads for the ministry, have certainly been and gone through some of the processes. For example, the UK, I'm pretty sure they have gone to the US and Canada also. I'm not sure exactly where on those, but with the UK definitely. So they are looking at those. Of course, DXC and Microsoft have delivered similar systems, not quite the same, but similar in Queensland, in other jurisdictions. So there are quite a lot of comparators. Mediation, the company I am associated with, has used its platform in the US and out of the UK. So there's a fair bit of tech expertise, as you can imagine there, and comparison.
I note that you did show a model of the Canadian system, which looked to be something akin to the Disputes Tribunal over there.
That's right.
So I guess that leads me to my question, why the family court to kick this off? Would the Disputes Tribunal have potentially been a better starting point?
Yeah, it's a really interesting one, and you're best to ask the ministry because I think there was a whole confluence of reasons. It's a really difficult court that affects a lot of people, and at the moment it's pretty slow, and you saw those figures about self-represented litigants. It's also sort of a microcosm, a bit of a test run for the really big one, which is the criminal courts and the district court. And it sits a little bit separately. And there are other factors, I'm sure. I just can't remember them all, but there was logic to trialling it first in the family court for those and other reasons.
I think we've got time for maybe one or potentially two more at the back.
Aloha, everybody, and thank you, Michael, for an excellent presentation. Totally fascinating. Kia kahemi. Teach at Te Piringa sometimes, and I have a role here at the University for Pacific People. So I guess as you're talking about going digital and thinking about some of the kind of requirements that we have in the family court for in-person meetings where people actually talk to each other to work things out, but also thinking about things like our Māori youth courts and how those operate. I'm just wondering whether you see kind of a hybrid model possible, and some of these courts where those in-person kind of innovations and advancements that we made might still be preserved and benefit from the digital. Mahalo. Thank you.
Well, thank you very much for the kind comments. I absolutely think that hybrid will be the way it works, and I think it will very much be up to the judge and the parties to think, how might this work best? Can we, is someone travelling from afar? Is someone better in a different language? Is someone got work commitments? And you can imagine, and in some senses that gives rise to more pressure on the judge to be sort of creative about what they're going to do. But I think very much it will, in the early stages, be hybrid at most. But in many cases, a proper trial will still do exactly what we did. But maybe a few more people will join online because of those stresses, I think.
Thank you. Maybe time for one more question. Well, I have a question. Surprisingly. I'm quite interested in the AI element, or the large language model element, and it's a two-part question. How are we going, to the extent that you can comment, how are we going to deal with the ethics element? Because everybody who's used ChatGPT knows it can throw up some reasonably fabricated answers, and as lawyers, our primary responsibility is one of candour to the courts. And the second part of that question is, large language models, the way they're built, necessarily tend to favour majority views, and how we're going to protect minority viewpoints and realities using those.
No, those are both excellent questions, and I wish I knew the answers. But that's well above my pay grade and capability. I think in the strategy, it simply talks about with appropriate safeguards, appropriate limitations, and ultimately the judges control that information. So it's very much going to be judicial controlled, I would have thought, and I would hope, because that's probably going to be the safest way.
Thank you very much. I'd like to ask everyone to just put your hands together one more time for guest Michael.
Thank you.